be bringing this to you every last Thursday of every month, where we come together as people in the ecosystem, tech enthusiasts, and we discuss topics that help to drive the business of technology. And this comes to you from the stable of Eco Innovation Center, an incubator and accelerator organization based here in Lagos, in the city of Lagos, 50 Awolowo Road. And Techbiz is one of the platforms in which we seek to fulfill our mission, which is about empowering startups and providing that hand-holding that is missing in the ecosystem to allow startups and tech organizations to be able to scale. And that's what Techbiz seeks to do. And what have we done with Techbiz in the last 124 episodes, 108 episodes, apologies, is we brought subject matter experts to the platform who have constantly shared with us different topics that helped startups to be able to understand how to navigate the headwinds, understand how to be able to get their businesses back on track, learn how to build a stronger fortified business so that they can be able to get their businesses to where they want them to be. And that's what we've done over the years. We've taken topics like, how to use the business model canvas to structure your business, how to grow your business, how to select your teams, things around talent management, investment readiness, and several other topics in the last 108 episodes where we've had these subject matter experts grace our platform. And should you want to see any of those webinars, listen to them, all you have to do is go to the link which my colleagues are dropping in the chat room, www.ecoicenter.com/webinar. My colleagues are dropping it in the chat room now. And it will take you to the 107 episodes of Techbiz and what we have discussed on them, and then you can learn from them. And should you have questions after listening to them, you feel free to join us in our community of about 2,000-3,000 tech enthusiasts and startups, where we can provide on-the-go feedback, support, answer all your questions. And most of the facilitators also are part of that community. Feel free to join that community. My colleagues are also dropping the link that takes you to the Techbiz Nation, where we can provide, apart from what we do every last Thursday of the month, where we can provide that support structure for you on an ongoing basis and provide the hand-holding. Okay. And so today happens to be a day in which I'm excited to have another person exciting to see put on the call. And I will mention one interesting thing she told me just before we started this, and I'm sure everybody will be excited to learn that. But today, what are we talking about? Okay. Today we're talking about a topic that I find quite instrumental for us to be able to unlock the wealth in the tech ecosystem. And it's about how do you move from idea to patent? Because again, patent is how you lock value. It's how you preserve and conserve value in all your ideation. I did do some work around frugal innovation, where we're trying to find out, just like in where you come from, where we're trying to find out, is innovation really happening? But again, if innovation is happening and we're not patenting those innovations and we're not locking them in such a way that we can derive value from them, and then to a large extent, the economy loses, the ecosystem loses out. And that's what this is about. And the world of technology and intellectual property or patent are closely knitted, because most of the innovations and ideas we come up with need to be put together in one form or the other for us to derive the maximum value. And I have a subject matter expert that will be speaking today, and I won't take your time. I'll just get on the platform. She's an author, she's a host, she's a founder and an intellectual property and technology transfer professional with over 16 years of experience in protecting and commercializing IP. She has transferred 65 plus technologies in her career and has been responsible for setting up and running a technology transfer office as the chief manager. She also heads the IP and technology transfer team at Foundation for Innovation and Technology Transfer, managing a portfolio of 900 plus patents. Man, that's huge. And she holds an MBA degree in technology management, apart from 2 internationally recognized credentials, which are certified licensing professional and registered technology and transfer professional. She's also a certified licensing professional, registered technology transfer professional, and a registered patent agent with the Indian Patent Office. Apologies for that. She assists startups, innovators, and entrepreneurs to convert their ideas and innovations to IP, effectively protect and commercialize IPs, and scout for IPs. She's a recipient of the Global Women Leaders Award 2021, Best Woman Mentor Award, International Inspiration Women Award 2021, and runner-up to Women Power Impact Creator 2021. And of course, the WIPF Power Women in IP 2021. I will add the last part to also say she was born in Nigeria, and for the first 8 years of her life, she was in this environment before she went to school. Ladies and gentlemen, please join me in welcoming our facilitator, our subject matter expert for today, Pooja Bhatia Vasika, the Chief Executive Officer of Innoberry. Thank you very much, and thanks for honoring your welcome.
Thank you so much, Victor, for the introduction. And I apologize beforehand for my throat. My daughter has been transferring to and fro infections, so my throat is bad. But thanks a lot for inviting me, and thank you everyone for joining in the evening for this session. IP has been always been close to me. There are so many ways we interact with IP without realizing that we are actually interacting with IP. So even this Zoom call is one of the IP forms.
Yeah.
And Zoom, the name itself, is also an IP. So today I'll be walking you through what is IP, what are the different forms of IP, and also how you can create a pattern based on uh, right from the first stage to the end stage. So before I share my presentation, I would also share a small story with you.
Yeah.
Is my slides visible?
Yes, it is. We see your slide. But it's not in PowerPoint show, so you might just want to put it on slideshow.
Okay, just a sec. Yeah.
Great.
Is it visible now?
Perfect.
Okay.
Perfect now. Thank you.
So imagine that, I don't know how many of you are aware, but there is a kind of diabetes that the pregnant women also have. It is called as gestational diabetes. And during that time, if they want to have ice cream or any sweets, they can't do it because it's not, their blood sugars will go high. So they can't tolerate it. So now, if you want to come up with an ice cream that is suitable for gestational diabetes, where women can enjoy those ice cream, you think of it that this is a problem. So that is your ideation step, where you are starting to think about the various solution to a particular problem of creating an ice cream which will be suitable. Now you come up with different combinations that you could have something which is lactose free. It could have, say, peanuts. It could have something to do with coconut. But then for both, for the last two ingredients, most of the people are allergic. So then you have to reiterate and think about another alternative. Now you have finalized the formula for that particular ice cream and created few samples, maybe tested yourself. You know it is testing good. Then you kind of upscale it, create more number of variations and test it out. So at that particular time, you have crossed the POC or the proof of concept level, where you have established that whatever you had ideated, whatever you had thought of a solution to a particular problem is working. This entire process is the innovation process. And at each step, IP comes into the picture. So let's talk about what IP is all about and how you could have a patent and what are the do's and don'ts for it. Now, most people use two terms frequently, IP and IPR, while both of them differ. Intellectual property means something which has been created. It could be an invention, a poem, a slogan, a name, and all these would fall under the category of intellectual property. But when you file an application in a particular country with a particular patent office or a trademark office or a copyright office or a design office, and they grant it, then it becomes intellectual property rights. So, till the moment it is not registered, not protected, it is intellectual property. Once it is protected, it becomes intellectual property rights. Now, both of these also differ in the scope, um, how each of them are protected, what are the different criteria. We'll be talking in a bit about it. But generally, IP has no life because it doesn't have any right connected to it. But intellectual property rights have a certain limitation in terms of the life, as in they are applicable for a certain period of time only. Now, when you think about intellectual property rights, they are categorized into different categories. One is patents, the most common, which is well known, designs, trademarks, copyright. So now the way I am presenting my presentation, the way I've created this butterfly is my copyright. It is the copyright of Innoberry because I have created it. You could take the content and redo it in a separate way instead of the butterfly, display it in a different manner. Then it becomes your copyright. And the way you give the presentation becomes your copyright. So there are a lot of categories, but for today's discussion, I would be limiting it to these four because these four are very, very critical for any innovator or startup. So I'll repeat the categories that we're going to talk about: patents, design, copyright, and trademark. A patent is generally given for something which is technical in nature and it is solving a particular problem. So anything which is non-technical, like a business method, may not fall under the category of patents, except in few countries. Like in US, we have business method patents, but in Europe and rest of the part of the world, we don't have a business method patent. Generally, the patents would cover a technical aspect where you are solving a particular problem, and it is a legal right given by a government of a country. So when you file the application with the patent office, say you filed it with the Nigerian patent office, then they would examine the application and give you the right. So once they do that, it becomes a legal right. You have the complete ownership of that patent, but only for 20 years. So in lieu of the disclosure you have made for your technology to the government and to the public, you get monopoly rights for 20 years. After that, the information goes into the public domain. Anyone, anywhere can use it. Patents can be granted for products or process, or it could be a combination of a product and a process, though I always advise separating them as different applications so that you have a portfolio. So if we take the example of ice cream that I spoke about, you could have a patent on the ice cream combination composition itself, and also on the process of how did you create it, how did you combine the entire ingredients and ensure that they remain stable. So those could be covered as different application. The main thing that the patent allows you is to prevent others from making, using, or selling your invention. So if you have created something, if you have created that ice cream, you can stop others from making it, selling it in the market, provided you have a granted patent with you. Now, for a patent to be granted, there are three main criteria across the globe that need to be met. It needs to be novel, it needs to be non-obvious, and it needs to have an industrial application. So, novelty means that it isn't just novel in a particular country, but it is novel across the world. So, if you have a solution that is developed only for a particular country, uh, say if it's addressing a particular problem in a specific country, uh, in that case, you could find out if there is any other solution similar to that in any other part of the country. I would like to tell you at this point that a patent is limited to the country where you file the application, but the novelty, unfortunately, is judged by across the globe. So if it is there in any written form, even as a blog, if it's a digital content, if it is a digital thesis somebody has written, that could be used to prove that the invention is not novel. Inventive step or non-obviousness is usually defined in terms of the people skilled in the art, which means that those who are in that regular business of using or working in that particular invention field of invention, so they, if they know that it is possible to create such a combination or to come up with such a solution, then it is not obvious. So to in order to cross that barrier, There are a lot of experimentation that needs to be done to support that there is an inventive step involved in it. Industrial application is the easiest. It's easy to show that you could, scale it up and have an industrial application. But the first two are the difficult conditions to be met in case of patents. But this is not all. There's still more conditions. Every country have different laws, and there are certain exceptions as per the one of the treaties which has been created to govern intellectual property. So the exceptions would again define what is allowed and what is not allowed. So in US, everything under the sun is patentable, but still there are laws, case laws, and which also have an effect on what is being patented. Similarly, in in addition to the case laws, you also have to see what is it that you are patenting. Is it a technology? Is it something that has a technical aspect connected to it? Then only you can go ahead for a patent. So now, when you have something that you have created, go through the checklist to see, is it technical? Is it related to product? Is it related to process? If it is yes for any of those questions, then you can go ahead for filing a patent and check for its novelty, inventive step, and industrial application. Designs are something that are related to the aesthetic look and feel of a particular product or an item. They would only be used in terms of enhancing the visual appeal. And in case of product, you could distinguish between one product and the other. If you are aware, Coca-Cola has so many different bottle designs. I remember there used to be Fanta bottles and Coca-Cola bottles that were different. The shape was different. So the shape itself is the aesthetic value that they have created, and that is sufficient enough to distinguish between one product of theirs from the other, right? Because Fanta now is within the portfolio of Coca-Cola. So, but still, because of that particular pattern, because of that particular shape, you are able to distinguish. So designs are just for the look and feel. They will not have any technical aspect connected to it. Trademarks are of various varieties, but generally they are given for anything, for the name of a product, for your business, for services. It could be something like a logo, a slogan. It could also be an audio. It could be a sound that you have created, which, there are a lot of content creators who have a particular music running, or if you have seen in the podcast as well, there are musics that are involved. So these are kind of a combination of trademark and copyright, where the music could fall under the copyright also, but it could be a trademark if a particular percentage, a particular length of it is protected. Now, the trademarks could also be slogans. So most of the slogans like Kit Kat has, take a break, have a Kit Kat. So that slogan is also a trademark. Trademarks can be again divided upon if they are certifying a certain quality, like Egma is certifying a certain quality of a product. It could also be smell. There were rose smelling tires. I don't know what benefit they got because nobody is going to smell the tires, but there were rose scented tires, and those were trademarked. Then you also have something where if you are lot of business owners are working together as collective, then they have trademark which everyone uses. The another category is well known. If you have a trademark which may not be protected as a trademark, but it is well known. So over a period of time, it gains a certain distinctiveness, and that is why it is known. People can connect with that particular name or a slogan or a logo, and uh, it becomes it to be called as a well-known trademark. Copyrights are the simplest because you don't have to do generally don't have to do anything. It is generated automatically. The moment you create something, it is created. But to enforce it, you still need to register. Any unregistered copyright is unenforceable. So remember, if you are creating any literary or artistic work, if it has something to do with software, Even the content of the website, databases, the way your database is created, structured, the elements are would fall under the category of copyright protection. So books, manuscripts, um, any of the paintings, drawings, maps, even the way Victor has structured his talk, it falls under the copyright uh, category. But yes, do remember that if you want to enforce it, you would still need to protect it, because without protection, you won't be in a position to go and fight with anybody. But again, this is limited to country to country. Now, why do you need to protect IP? I'm sure it is important, and that's why you are here for this session. But intellectual property for a startup, for a business, for an innovator is also important in terms of investment. When you are raising funds, especially the VC funds or through grants, there are sections in the grants which ask you if you have any intellectual property, or what is the intellectual property strategy that you plan to implement, or what is the future of this IP? Would you be licensing it out? So all those questions are there in the grant section, grants where you are trying to raise funds. The VCs would also do a due diligence to see if what you have actually created or the startup is based on does own the IP that they're using. It is also useful for branding because the product labels would say this is a patent pending or a patent granted product. So that is a form of branding for the company because you're telling that you have intellectual properties, and also generating revenue. So how do you generate revenues? There are a lot of IPs that we create. We go for lesser amount of IPRs. We protect them, we protect less number of IPRs, but then you could still use the IPRs by licensing them to third party instead of keeping it on your own shelf. So if you coming back to the ice cream example, if I don't want to use it myself, I don't want to start a company, I could give it out to another company or give it to an entrepreneur who would create a new company on basis of that patent that I have protected. So that way, I would be getting the revenue for myself in forms of lump sum, in forms of royalty, because I licensed that particular patent to them. These are the steps involved in creating a pattern. So what happens is that you have ideated, then you come up with the solutions and alternatives, you test out your idea, then you go ahead with the reduction to practice, as in you create the product or you work on the process or both, and then you have a proof of concept that this is working. Now, once you have that, in fact, even before you reach the POC level, you should do a novelty search to see if anybody else is working on the same thing. Are there any similar patterns which will prohibit you on working it in your own country? So, if you are planning to market that product only in within Nigeria, then you should look for the patents within Nigeria to see if anybody has protected it. If not, then you have the freedom to operate. But if you are planning to take it out to different markets other than Nigeria, then you'll have to look for the patents in each of those countries. So novelty search is useful in that way because you don't need to look for the data in separate countries. With one search, you could get information for the data from different countries. Now, once you have seen that there are no conflicting patterns which are going to influence your invention, either upstream or the downstream, then you can go ahead and draft the application, which is generally done by a professional who would help you in the legal drafting of the application. They would file it with the patent office. So, till the step it is filed, the invention is with you. The steps are to be taken by you. Later on, the entire process goes is done by the patent office where they would publish the application. It is published by 18 months. Then it is examined. Now, for the examination, you need to file in a request for examination unless and until you knock the door of the patent office and tell them that you have to examine my application. They won't do it. So remember to file the request for examination. Once the examination is done, they would send back a report telling you if there is anything um, that needs to be changed in the application in terms of the claims, or if they have found any patent or non-patent literature, which is affecting novelty and inventive step, or they need more data, that would come as form of the examination report. Once you cross this stage, then it is granted. So this entire process is a time-consuming process, and as an inventor or as a startup, you would need a lot of patience for it. And I would suggest to have patience because you are creating something and you need to protect it well. A lot of people have misconceptions. One is that there is global IP. No, you wherever you are filing the application, you will only get rights in that particular country. You don't get global rights, and there is no mechanism to get global rights. If you are looking for rights in multiple countries, you will need to protect in all the individual countries. Um, so if you are looking for, besides the African countries, you are also looking to protect in Europe or in US or in any other country, then you have to file an application in that particular country. Now, not everything is patentable. You will have to look at the exceptions that are given as per the laws of the country. You also need to know if it is novel and inventive enough to be granted. Ideas are not protected because those are ideas, and you would be wasting your time on just protecting an idea. Try to work on something, have at least the POC level ready before you think about going in for a patent, because that way you have something concrete to protect. An idea would still be at an early stage and you may not be protecting it effectively. So we will need to refile or have another application. So to avoid doing that, don't file at the idea stage. You can start working on it, but file when you have at least a POC ready. Again, an idea is not protectable either as a trademark or as a copyright or as a design. You would need to create something. Anything tangible is what is protectable. So ideas per se are not protectable. Now, with startups, I have generally seen what they do is they try to save money and they try to file the application in names of the founder. And the startup is the one that has, you know, invested in creating that particular invention or the IP, but the IP is protected as an IPR in the name of the founder. Now, what happens is when the startup starts using it, it is actually infringing the rights of the founder because the application or the IPR was in the name of the founder. So don't do that. File it in the name of the startup of the business or the business that you are operating under so that the business has the complete rights over the IPR. In case you have already done, don't worry, you have a solution. Just license it out to the startup so the startup has the rights. And if you are raising funds, then this question won't come up. Hey, how are you using this IP if you don't own it? So transfer, either license it or transfer it to the name of the startup if you have already protected something. Don't try to file it on your own because there are a lot of AI tools also coming up which help you in drafting. But then you need to understand the rules that each country has, and you have to adhere to the case laws which are there. There are a lot of amendments that take in the act. So you need to keep in mind those pointers also so that when you have the application, at least it is in line with the regulations. If you have something which is not properly drafted, it won't be granted in any way. So you are kind of, wasting your resources on filing on your own. Involve a professional to help you with it, but think about the budget. Budget, it is an investment, not just the filing, because that is not the end of it. If you remember the chart, it has a lot of steps. So for each step, you need money. And even after the grant for a patent, you would need to still maintain it every year till 20 years. So you need maintenance money also for it. So think about the budget to pay out the official and the professional fee. Don't disclose it before you protect it. Once you have disclosed, you lose the novelty. Your own disclosure would be used to kill the novelty. So don't disclose anywhere and don't assume that whatever you are using is infringement free. Check before the startup starts using anything so that you don't have any implications later on. Whenever you are starting any ideation process, start with the first step to look out what is already there in the market, what is already being done. Don't reinvent the wheel. So keep doing the searches. You could do a landscaping search as well, where pattern and non-pattern and the products in the market could be seen to identify what is already there. You will also get to know who all are your competitors. Now, once you have started the process of filing IP, you would need a tracker to keep track of your various IPs, because it is not just one IP that you would be filing. I am presuming you would have a portfolio of IP. So you would need a tracker to keep a track of the applications and even the granted one later on, so that you can maintain them on time to time basis and you do not miss any deadline. As a startup, also, you need a policy framework to define the ownership. Once this framework is in place, it's easier to capture the IP rather than losing it. And it also helps you in defining who is the inventor. Say you have collaborated with a university will have its own policy. So you also need to have your policy so that you could negotiate with the university and define who all would be the inventors from your side. With most, this is specifically with the universities, I have seen that, there are forms that are be submitted at the time of the filing of any application, and those are signed by people who are not authorized. The inventors would sign themselves. Now, they are not authorized to sign on it. Every institution has a particular procedure who would sign. Either it is the VC or it is the registrar, but then uh, these two people are the authorized people to sign on any agreements or any form. So if as an inventor you are signing, that application is null and void. So have that part also included in your policy framework. Now, if you look at my slides till this point, the look and feel of my trademark is same, because I have adhered to the trademark usage policy guidelines that I have created for myself. That this is the amount of space it would take. It should be clear. It should not be hazy. So all these kind of pointers should also be part of the policy framework, so that when you are using your trademarks, you know how to use them. But it's not that you are only going to use, there would be third party who would be using them. So you could just tell them, hey, I have a trademark guidelines, you have to adhere to these and use it the way I have specified. The last but not the least, you should look into freedom to operate, so that you are not infringing on anybody else's right. I would conclude by saying that it is essential to identify and protect the IP. Keep a strategy ready with you, which is in line with your business strategy. The business strategy and the IP strategy have to go hand in hand. Try to bring different forms of IP together so that you have a bouquet of IPR rather than just one form. Um, you don't need to necessarily create, you could look for what is already created and license it out for your company to use it. So, with this, I end my presentation and I look forward to the questions.
Thank you so much. I think that was quite instructive. Thank you. And it's a very complicated question when you topic when you talk about IP. People begin to think of lawyers and luminaries and all the big stuff about protecting your idea. But you've made it quite simple. You've simplified it. You can protect your idea, you can protect a concept, you can license it out. And I think big businesses have seen how to use this, when you talk of franchising, when you talk of the power of the logos, when you talk about the brand, the brand pattern, how it's written, how it's used and all that. I think this falls under the stuff that needs to be protected by startups and companies to be able to drive the overall valuation. And I think ultimately what I get from this is for us to really be able to preserve and maximize the valuation of our startups, they need to see how many more of their ideas and how many more of their intellectual properties and concepts and MVPs they're able to protect. And I like the fact that you also help us to understand the fact that you can't have a global IP protection. you need to, you need to take the pain to grow from country to country where you're operating to make sure you've got that protection. And I think that's interesting because, again, startups can't scale without innovation. And innovation is only valuable when we protect that innovation that comes out, and there's a reward for the innovation. So thank you so much. I think we did learn a lot. But and let me see if we've got a few questions. And I think from the chat room, I think there are a few questions to you which you will be able to answer. The first is, how does intellectual property strategy fit into a company's overall business strategy, particularly in terms of innovation and competitiveness? How does the intellectual property, the IP strategy, fit into a company's overall business strategy, particularly in terms of innovation and competitiveness? You want to speak to that?
Sure. Thanks, Victor. I just wanted to make a comment before I proceed to the question. You did mention about the global IP. In a way, it's good, right? Because if there was something to file global IP, everybody would start doing it without realizing that they will have to maintain an IP in that country. So it's an expense. So it's a good thing that, there are individual IPs to be filed in different countries. So you could decide where do you want to invest. If you don't have a market, why would you protect it there? So in a way,
True.
it's good we don't have any global IP.
Yeah, I
Uh,
agree with you.
so coming to the questions, thanks for asking this question. The IP strategy has to go in hand, because when you start thinking about your business, either you are the business would be either rolling out a product or you would be offering a process or a service. So now, the day you create your startup, the day you have your website ready, you have a domain name, and that domain name itself is a trademark. And you need to check if it is already taken, right? You won't get a domain name if it's already taken by somebody else. So if somebody else already has a domain name on something that you are looking to protect that means you need to reiterate, rethink, come up with an alternative which nobody has thought of.
Yeah.
So your IP strategy actually starts from the day you start thinking about your business. When you start thinking about your website also. So it has to go in hand. When you are planning the product, think backwards, not forward. Because once you are going ahead with the product, you have to think, what if there are similar patterns? If somebody has created it, you am I infringing on somebody else, right? So all those factors need to be factored in while you are running your business. So um, it's not easy for a founder to do everything. So that is why I suggest create a team where you have expertise of everything. If it's not possible to have that expertise, at least have a professional or an expert involved so that they can guide you as you move along the business. You think about your innovation that you are developing, and the IP strategy would follow with it, because they would start thinking about doing the searches, doing the landscaping, how to protect it before you reach to the market.
Okay. I think that's quite interesting. And also to speak to the context of the Nigerian environment, in a place where we see a lot of head mentality, where people like to, once you build a big brand, people jump on it and want to take your colors, want to take everything because they know you've already created a market. The best way for you is to start from onset to begin to think, what are the things that really has my ideation, that this has the level, my intellectual property, and how can I protect it? And like you said, from the basic things, your what does a website look like? What's your color pattern look like? How do I do a mixture of my colors so that when people see a particular color, yellow, they know it's me, or red, or orange, or burgundy? Those are the things, even in terms of pattern, that people need to protect, because ultimately you could do all the work, grow all the market, a new player comes in, if you've not protected, gets all the logos, the image, sounds like you, and go ahead to protect it. And so because you have not protected your brand assets, your visuals and everything, you've left your flanks open. Somebody else comes along, sees that there's no protection, takes all those things in the market and goes to protect them. Those are kind of things that the games people play, to be able to steal market share, or challenge dominant people in the market. So ultimately, it's a way to preserve and store value and preserve, your ideas. And thanks very much for that answer. I think there's also another question here. Um, oh, that's okay. I have
I've
some questions.
made some.
Can you
I
discuss
have
the
made
role of
some
okay?
social.
Can you discuss the role of IP in mergers and acquisition and what considerations are important during due diligence?
Sure, I'll
Okay.
answer the earlier question, Victor, first. So if you have made a social post about it, try to delete it, try to remove it. This is what you can do right now. And just judge if you have hopefully not given out any of the details about the patent in it. If you have just mentioned that you have created an innovation without giving its technical features, you could still go ahead and file for a patent. But if that is not the case, like, in exhibitions or during paper conferences or virtual paper conferences also, we tend to present. So if we have not presented anything related to the invention per se, the key features, how is it created, how is it functioning, then you can still go ahead for a patent. But I would suggest to get in touch with a patent professional who could make a comparison and tell you if anything has been disclosed, so that you could still salvage the situation with coming up with an alternative solution for it.
Yeah.
um
Yeah.
Coming to the question that you had asked, Victor, can we discuss the role of IP in mergers and acquisition and what considerations are important during due diligence? So IP is very critical in mergers and acquisition. There was a time till 2000 when people didn't consider about IPs. They were trademarks that were left out of the deals because they were not aware. But now, most of the companies, what they do is when they start the merger and acquisition process, they already have experts on the team who would be doing the IP audit for that company. Even for a startup, even before it's been funded, the due diligence process has a major chunk on the IP part where they would be looking at what type of IPs you have. Are they granted? Are they in application phase? What stage they are? Uh, are they in your name? Are they in the name of the startup or the company? And how long has it been? Have you been using it? Is it an integral part of the startup or is it still lying on the shelf? So all these factors are something that they would consider. So while you are thinking about your IP, do remember to do a self audit from time to time to see if those assets that you have created are still actually useful or not. How are you using them? Are they live or are they dead? Because if you had filed an application, but you didn't follow up with the rest of the steps, you would actually be losing out on it. So you don't have a live application anymore. Even with trademarks, if you have a granted trademark, but you are not using the way you protected it, again, that is something that is, um, reducing the value of the trademark that you have protected. So these are a few of the pointers that you should keep in mind. Keep your applications alive, keep your granted assets alive, use them in a manner that they are, especially for the trademarks, in which they can be still have a value, and do carry out self audits uh, on what all assets you have and how what state of, they are in. A health check, I would say, if you could do for your own assets. The other question is, we got an offer from Pakistan startup to get manufacturing rights to our innovation, but they want us to do a joint patent. What would you advise? Well, I would advise that you file an application on your own in Pakistan and then you give it, license it to them rather than doing a joint patent, because they are trying to ride over. They want you to file a joint patent. I am not sure about the Pakistan Patent Act, but in India, if you are joint owners, even in US, if you are joint owners, you have the other party has the right to use it without telling the other party. So um, you would need to look at the act of a particular country wherever you are collaborating. So even IP becomes important in collaborations because you need to understand the IP framework of that country from where you are collaborating and what policies that particular company or a university has. So my advice to you would be to don't file it as a joint application, but file in your own name and then license it to them. How long does it take to complete? It depends. The processing of IP and the cost depends from country to country. Um, But generally, it would take at least 3.5 years to complete the entire filing of a patent. For trademarks and copyrights and design, it's close to an year if everything goes well and there are no opposition. So that is what is the ideal time it should take. I can tell you the cost of filing in US for a comparison. It's just the filing part takes 3,000 USD. So it's an expensive process. The professionals and the lawyers here are very, very expensive. A patent search itself is, I think, between a range of 2 to 3,000 USD. So IP is a filing process. That is why you need to have a budget beforehand. How can I, as a founder of a startup, evaluate the worth of the intellectual property assets within my company? So what you can do is that there are three different methods of valuation. But even before you start the valuation, I would request you to do the evaluation of your IP to see where does it stand. The IP or audit is one portion, but evaluation is where you look at how good the IP is in terms of if it is a patent, where all you have protected, what kind of claims do you have? Is it a granted or a published application? Did you follow it up or it's a lapsed one? So there are a lot of parameters through which you could evaluate how strong your IP is. There's a complete process which you could use. I plan to make a video on it. So once I do it, I'll share it with you on how to evaluate your patent or the IP assets that you have. Valuation is something where you come up with assigning a value to your assets. So those could be done by different methodologies, but it varies upon what exact asset do you have. So I won't be in a position to give you the exact methodologies because those are very, very complex. But you could look for the methodologies on cost approach, income approach, and market approach. So this was the last question, uh, Victor.
Oh,
That was there,
beautiful.
I think.
Yeah, I saw that. So again, I don't know from my team, any other question from across the platforms?
One more they have
I think
added.
I
Could you
one I come
explain
here.
the yeah?
Difference. Please
Could
go
you
ahead.
explain difference between trademark, copyright, patents, and which each might be applicable to a patent or to a business? Okay. So a trademark is something which will only protect the name, logo, slogan that a company has or a business has created. Copyrights only protect the literary or the artistic work. And in some of the countries, software falls under the literary category. So you could protect software also as a copyright. Patents per se are only for technology. If you have a product, if you have a process, that is when you have a patent in making. And when each of these would apply, trademarks start with the birth of the startup. So when I was thinking about Innoberry, I went through so many iterations to come up with this name. Um, I looked at the domain. Was it available? Does anyone have any claim on the particular name? Is it published anywhere? Is anybody using it? Then I went through various trademark offices, databases to check. Nobody has any trademark on it. So trademark starts with the life of the startup. And then uh, copyright again would also start once you have a digital presence, when you have a website ready with you, or if you are operating through LinkedIn or even Facebook. So, whatever content you are posting, like even for product and our services, we create small videos, right, to explain what we are doing. So, those are kind of things would also have copyright. So, that is how it is applicable for a business. And if you are working on any product or an innovation or process innovation, then the patents would come into picture for you. I hope I have clarified that question. The other one is, what are the common misconceptions about intellectual property rights that the business often have? Well, there are many. One is the global IP. One is that they don't need to protect. Few feel that they will protect it at a later stage, but at a later stage, this too late to protect it. You might have missed the bus. Somebody else has already protected it, or you have yourself disclosed somewhere. So we had a case where one of the startup had hired students. They were working on a project, um, and they had recorded few videos. They put it up on YouTube. Now, it is a disclosure. They couldn't file a patent later on because a disclosure was made. So, uh, you have to capture your IP and you need to set in the processes right once you are starting to work. Even before you hire your first co founder, you need to have proper agreements in place and start thinking about the IP. Um, and don't wait for a later stage, because there are changes that take place. There are a number of papers and publications that are coming out, so it is possible that someone else might have found a solution to the problem that you are trying to solve. The other misconception is that IP is not expensive. It is expensive. You need a budget to maintain it. It is an asset also. Most of the VCs, the venture capitalist, would fund your startup if you have a particular asset associated with you. If you are going in for grants, then again, having an asset is very useful. And if you don't want to go through any of these mode, you still have the mode of licensing and monetizing it to create a source of revenue for yourself. So these are some of the misconceptions that they exist about IP, but IP is not a devil. It's a very useful asset. So do think about protecting it and creating a budget for it.
Yeah, thank you so much. Quite insightful. I think the questions keep coming in, and thanks. I mean, so that when people go back and listen to this webinar again, it becomes quite instructive for them to be able to answer all the questions. And so we'll take the last question for today, and then we can call it a day, and we can let you and everybody get back to their evening. So you mentioned the ability to patent a process for solving a problem. How can I protect my process if there's a similar one already existing? And I think she's spoken to this before. If there's one already existing, I'm not sure, but again, you can speak to that. This is the last question. Can you patent a process that was created, but there's another alternative already existing? Can you patent that?
So if something is already patented, and what so if you have created, let me give you a very crude example. If you have created a lemonade with salt and sugar, and there's a patent already on the lemonade with salt and sugar and lemon, you also have lemon, so the ingredients are same, everything is same, the process is same, so you can't go ahead because then you have no novelty there. And secondly, if it is in within the same country, if it's filed within Nigeria, then you are actually infringing on the other party's IP, so it doesn't make sense in protecting it. But if you have made significant difference due to which there is um, a change in the storage, you are able to store the lemonade for a longer time without it going bitter, then you have changed, you are created a separate solution to a problem, and that is a separate process. You could go for that. But if you are have something which is same to what is already there, then you can't protect it. But yes, do conduct a novelty search or a landscape search before you start working on something to understand what is already there, so that you're not reinventing the wheel.
Great. Thank you so much. And I think that was quite insightful. And I think the questions also spoke to it. And I'm sure for all our colleagues and guests who have been part of the webinar across all the platforms, I'm sure this must have been a very insightful session. I want to say a big thank you for our facilitator for today. We're excited to have had you. Thank you for gracing the platform, and thank you for sharing from your wealth of knowledge. Intellectual property is not something that people speak a lot about here. People don't know so much about the process. But again, you've opened our eyes into seeing it as an asset. It's a critical part of an asset of an organization. And as we build our startups, it shows that we need to have a strategy for intellectual property so that the valuation of our companies and the overall well-being of our companies are protected for the long haul. And thank you for sharing this, and we're very grateful. Thank you so much for your presence. And to everybody on the call, thank you for taking out time again to spend time with us. We do know there are so many other things you could be doing with your time, but we thank you because you're always part of this community. You're always coming to come contribute, to come learn, and to come be a part of the handholding process that we provide as a center that wants to always see how we can help and support the scale up of startups in the ecosystem. Thank you so much. And to the wonderful team who puts this together, the team from Eco Innovation Center, I want to say a big thank you to you for always making sure this happens each free every last week of the month. It's a big thank you to you guys for what you do. This has come from the stable of Eco Innovation Center. If you want to be able to play back and listen to what our guest today has spoken about, I'm sure the recording will be up on our website by latest by 12 noon tomorrow. All you have to do, my colleagues will drop the link, www.ecoicenter/webinar. It will be there, and you can access this and all other previous episodes of 108 episodes of Techbiz webinar. It's available. And should you have questions, you want to join a community that provides support for you on the journey of startup, they also have the link that takes you to the Techbiz Nation, over 3,000 community members where we support each other and we share information that helps us on this journey of growing the tech business and growing our startups and being a part of the community. This is a Co-Innovation Center. We offer incubation and acceleration services, and of course, upskilling and enterprise development services. Should you want to know more about the things we need to do, our programs coming up or our boot camps, please go to our website. And of course, you'll be able to get enough information about us. Upcoming are two of our critical activities, Marketing and Media Hackathon, the only one in Africa. We think it will be exciting for you to be a part of it. Register to be a part of this hackathon where we look at how the intersection of marketing, media, and technology, and how it is redefining the landscape of marketing and advertising in Africa. Please be a part of it as you register on our website. Also, Out of Technology Lagos, another flagship platform where people come together, AOT 6.0, the largest tech gathering in Africa. It's also coming up later in the year, and you can please sign up to either attend or be a sponsor or be a partner, and we look forward to you collaborating with us in all the initiatives that we put up from Eco Innovation Center for the benefit of the whole ecosystem. I want to say a big thank you to everyone for being a part of this. I remain the host of Techbiz and the founder of Eco Innovation Center, Victor Gbenga Folabi, saying thank you for keeping a date with us, appreciating our facilitator for her time, saying thank you, Pooja, for being a part of this, and all the best, everyone. See you and thank you. Thank you, Pooja. Thank you
Thank you
so
so much, everyone. Thank
Thank
you.
you then. Bye.